of the days. Hello. I'll say it again, dignitaries on the days and of the days. Very warm welcome on my behalf to all of you for this Constitution Day. It is so important in our lives. No event in our life would be complete if we are not aware of what the Constitution gives us. We say that Constitution is the mother of all laws. We get all our rights from the Constitution. And this day would be incomplete if we don't honor Sri B.R. Ambedkar, who was the father of this Indian Constitution. Now, I'll just give a brief history. Sheikh Sir has already given a brief intro about how this Constitution Day has come into being. Initially, this Constitution started somewhere in 1946, the drafting. It took 3 long years. And finally, on 26th November 1949, this draft Constitution was conceptualized, the Constitution became ready. And finally, it was adopted on the Republic Day on 26 January 1950. But why this 26th November 1949 is so important? That was the day when the final copy of the Constitution was actually ready and which was signed by the eminent persons. Now, why is it so significant? And it goes with Babasaheb Ambedkar. He was the chairman of the drafting committee. We call him the father of the Indian Constitution. 2015 is a significant year. 26th November was always called as the Law Day. But something changed in 2015. 2015 was the 125th birth anniversary of Sri Bhimrao Ambedkar, fondly called as Babasaheb Ambedkar. And to commemorate this 125th birth anniversary of Ambedkar, the government of India declared that the entire year will be celebrated as 125th anniversary of Ambedkar. It also decided that we will have an Ambedkar memorial and we will have a statue in honor of Ambedkar. And it was at that time, in the year 2015, that the government declared that there could not be a greater honor to this man than to declare 26th November as the Constitution Day in his honor. That is how this term Constitution Day or Samvidhan Divas came into existence on 26th of November. Otherwise, earlier it was always called as Law Day. Now, today we talk a lot about Constitution. And when we talk of Constitution, we always talk about our rights. We say that our fundamental right is violated. We say that our right to speech is violated. Our right to expression is violated. Our right to property is violated. And we commonly use all these terms. की माझो हो रायटाचे उल्लंघन जाले, त्या रायटाचे उल्लंघन जाला. Now, from where do we get all these rights? All the rights come to us from this supreme document called the Constitution. And we all know that the Constitution exists. And we often fight so many matters in courts. And we have so many debates across, whether it is a political debate, it's a debate in the court of law, it is a debate between the executives. And we all then say, ki hai amche Constitution and basana. So we all know that the Constitution exists. The Constitution gives us certain rights. Now, if we see, the Constitution is divided into different parts. First part of the Constitution talks about who is a citizen of India, what the Constitution applies. And then we conveniently ignore that part and we focus only on the main part, which talks of all the rights available to citizens. आम्ही रोखडेच म्हणटा की ताका हो कायदो एक आणि म्हाका तोच कायदो दुसरो कित्याक. So we look at Article 14, which is violation of right to equality. Then there is Article 15, Article 16, dealing with different situations. Then we come to Article 19 and we immediately say freedom of speech, expression, freedom to have our own profession. You start a business, the government says you are not allowed to do this. We immediately challenge saying that how can the government stop me while somebody else is doing similar business? So all these questions come in our mind and we say that there is a violation of all these rights. And for us as a citizen, the constitution is more focused on violation of those sacred rights which we feel are very supreme to us. But we also forget that the constitution is not just that. The constitution also deals with something called as the directive principles of state policy, which is equally important as much as citizen rights which are protected from Article 14 to maybe Article 32. These directive principles are also important because it puts the duty on the state and says what the state should do for its citizens to make the state, to make the country a model state, a model country. And it is this part which goes hand in hand with the fundamental right. Because while we have the fundamental rights, the state has an obligation to make it a model state. And often we find that there is this conflict between we saying that we have a fundamental right and the state saying that they have a right to regulate our rights. And they say that we are regulating the rights because according to us, this is our concept of a model state. Now when we have political ideologies, we will always say that this is my political right, this is my fundamental right. And the state who is in power says that no, this is my right to regulate your right. So guys, you have to see how now this all flows from one constitution. Now while we are fought in this fight, we talk of fundamental rights, we talk of what the state can do, what the state should not do. But we often forget what we are also supposed to do. And I was very happy to see that at the start of the event, there was a pamphlet which was circulated to all of us here. I hope everybody has had a cursory look at it at least. But Mr. Prabhakar Dingle has done a fantastic job, and that was something which I wanted to touch last in my talk. On the last page of his pamphlet which he has circulated, he has mentioned about the fundamental duties. And that is something which we, every citizen, we owe to the state, which we owe to the country, and which is more often than not always forgotten. We only talk about our rights. What about our duties to the state? What about our duties to the nation? So if you see now, the constitution as it was framed was beautifully divided in the three parts. Our rights, states' rights and obligations, and while we talk of our rights, what are our duties? So this is what the constitution was to begin with. Then if you see the constitution, it talks of how this power has to be separated, because power corrupts and absolute power corrupts absolutely, is an old saying. So the power should not be concentrated in one hand, it should not be concentrated at one center. And this applies equally to the legislature, which is one wing under the constitution, to the executive and to the judiciary. So absolute power to the judiciary becomes a big question of discomfort to the executive. If absolute power is given to executive, they will sit on the head of the judiciary. And if none of this works, and if you are given absolute power to legislate in the assembly or parliament, they can sit on the head of the executive as well as the judiciary. So how to separate these powers? So the constitution then went into this aspect of separating the powers and creating three different wings. And then the last part was, while we separate these powers have to be effectively channelized. So you had the center and the state, which was called the separation of powers. So this is what we know about the constitution, and finally we have the constitution in our hand. We read it every day. But how many of us know about the history of this constitution? Or what went into making of this constitution? There will be many speakers who come and talk about the finer aspects of how things are violated, etc. And since this gathering is more of the Congress gathering, I will start briefly, I'll be very brief, give you different things of how it moved and who are the persons responsible. And I'll devote a little bit of time to Baba Saheb Ambedkar because he was the founder, chairman of this commission. Somewhere in 1943, this concept of, in fact in 1933, the Congress as it then was, came up with this idea that now we are moving towards our independence. So there should be a supreme document which will guide us once we become independent. So the search for a supreme document started way back in the early 1930s. And that is where the thought had come. But nothing really went on from 1933. We had no idea how to move ahead. And nobody had anticipated at that point that India would go through the bleeding moment of a partition at that point of time. 1945, the World War had almost come to an end. And at that end of 1945 war, there was a Simla conference. This is where the thought of a real constitution came in the Congress's mind. And they said that we must work towards making a concrete document. So in 1946, the thought of this constitution assembly originated on 13th of December 1946. And this thought was sparked by none other than Pandit Jawaharlal Nehru. So he said that we should come up with a blueprint which is called as an objectives resolution. And I'll quote his wordings. He said that India is a history of 5,000 years. And from the very dawn of that history, which might be considered almost the dawn of human history till today. So Pandit Nehru was trying to tell us that we have to now codify 5,000 years of history into a book. So how will we do it? But he said that we must do it because we want this document to be a model document for the rest of the world. Now, Indian constitution is the longest constitution in the world. Why? Because it takes inspiration from Constitution of America, Constitution of England, inspiration from the Irish Constitution, from the Canadian Constitution, from the French Constitution. So these different constitutions, the best parts of this have been put together and made into this one document. Pandit Nehru's dream was to give India an independent sovereign republic and to give a document which earmarks these features. Now, as I told you, constitution is in different parts. Now, when India was under the British rule, we as citizens, if our rights were violated, we had to go to the courts which were there, set up by the Britishers. We did not have access to Privy Council which used to sit in England. But all matters would travel to Privy Council and invariably we decided not so much in the Indians' favor. So the thought was, now if the Privy Council had to be done away with, we needed a court in India. So the first thought was, let us have something called as a federal court. Now why I am telling this is because so many matters from Goa reach the Supreme Court. And we say Supreme Court is now the protector of the constitutional rights. So I'm giving a brief touch of how the Supreme Court came into existence. We had the Privy Council. We had to do away with the Privy Council with the entire court set up by the British government. So the thought was that let us set up a federal court. So in 1935, a federal court was set up. This is much before the Constituent Assembly also came. But then they realized that this federal court was not dealing with the situations which we wanted as independent Indians. So again the thought was that we need a court better than a federal court which will deal with this situation, and we should have a centralized court, a Supreme Court. That time nobody thought that it would be actually coined as the Supreme Court. But they said that we want the Supreme Court. So this is how initially the thought progressed. And then what happened was, India was going through a phase where there was so much bloodshed in history. We had so many wars. आमच्या राजांच्या मध्येच कितले वॉर झाले. Then we were fighting our battle for independence. So ही वेगळी हिस्ट्री आशिल्ली. And why this history is important? And how this framers of the constitution have taken this into account. त्या टायमार इंडियन वेगळे वेगळे रिलीजन्स आशिल्ले, वेगळे कास्ट आशिल्ले. सोशल बॅकग्राऊंड सगळ्यांचो वेगळो वेगळो आशिल्लो. आता इतले सगळे लोकांचे राइट्स कशे प्रोटेक्ट करपाचे. And we were now trying to give a document which is the first document, and हातूंतल्यान आता हे सगळे राइट रेग्युलेट जाता. So this Constituent Assembly was framed, and in the Constituent Assembly we had very important persons. The first important person in this assembly was none other than Bhimrao Ramji Ambedkar. Now I just briefly read about him because that is what is important. He came from a very low background. He initially was from Satara, which many of us may not know. And from Satara, the family moved to Bombay. Then he finished his education in Elphinstone College, and he then moved into coming into social life. He was a very popular person in Mumbai. He became a councillor. And then once he gained popularity as a councillor, he then came into the Bombay Legislative Assembly between 1924 to 1934. Then he was appointed as a lecturer in various colleges. And finally, he was elected to the Constituent Assembly from Bengal in the year 1947. But in this time, he was a very knowledgeable person. He had knowledge of law, philosophy, literature. If you see his biography, you couldn't say that there was something lacking in his degree, in his education. And therefore he was made the chairman. And along with Babasaheb Ambedkar, who was the chairman, there were notable persons. I just mentioned three. One was Alladi Krishnaswamy Iyer, one was K.M. Munshi, and then there was Benegar Narsingh Rao, or B.N. Rao. Now, Babasaheb Ambedkar, he chaired this committee. Why these other persons were important? They say that B.N. Rao, he was so good in his work. He compared the constitutions of different countries, and his grasping power was so strong that he could read the finer details of the constitutions and decide what was best suited for India. That is why when the commission was selected, we had majority number of lawyers, teachers, philosophers, because this is what was had to be dealt with. So B.N. Rao was the person who basically argued, saying that when we are doing the constitution, we must have fundamental rights as a focus in the constitution. And concept of fundamental rights was not something which was not known to India, because this right was fought in different ways, even in the erstwhile India before partition and before independence. We were fighting for our rights for independence, which was itself a fundamental right. And this is why his contribution while making this constitution was very important. Concept of fundamental right was well known in America, in UK, and in US UK, the concept was that nobody can be, or no person's right can be taken away except by due process of law. And this was something which was not known to India because we were an infant democracy. We were just being born. So this concept had to be made known to people of what is the due process of law. And how do we tell that this right can be taken away only by particular manner. That is how this whole concept of fundamental rights was brought in through this idea by Mr. P.N. Rao. Then the next person there was Mr. Tej Bahadur Sapru. Now Tej Bahadur Sapru was such an intelligent person. He was the one who visualized that you need an institution right at the center to protect our rights. That is where he advocated the idea that the federal court is not enough. We must have a Supreme Court. But he had a further vision. He also said that while we create this court, we must also remember that we should say how the court should function and what should happen with the judges of this courts. And that is where the concept of retirement, etc. came into being. Otherwise, imagine a person who sits on that chair but has no age of retirement. He will go on deciding the way he wants. So he advocated that the judges, however eminent they be, whether they are the Supreme Court or High Court judges, they must retire at a particular age. And then he advocated that while there should be a retirement age, there should also be a fixation of a good salary for these judges. He said that while the judges do this service, we must not make them work hard and earn peanuts. They must be handsomely rewarded for the work that they do. Because if they are discharging such a high positional duty, there should not be any other thought that comes to the mind that we have given up a life for the cause, but we are not being rewarded. So he was the first person who said that you must reward the judges by a good salary, and that not depending on their economic status, but the wages should be equivalent to the work which they render. It's a recognition of their work. Then, with this thought, another important person there was Sri Vallabhbhai Patel. Vallabhbhai Patel took this idea forward, and he said that while we have now decided to have a Supreme Court, we have thought of their retirement age that they should get salaries. He said that this power should not be concentrated only at the center. Because if we give the entire power to one court, then we also don't know what will happen. So, advocated the idea then that the power should be channelized, decentralized. And there should be Supreme Court, there should be High Court, and the power should be spread. They had this vision, and this is what they wanted to give to India. And he said, Vallabhbhai Patelji said, that he remarked that the judges are well past the peak of their usefulness at the age of 60. This is what he said. Whether it is right or wrong, we don't know. But then, this thought has sown way back in the year 1946. And he agreed with what somebody else said, that this is how it should be. Then there was one more gentleman, an astute person called K.M. Munshi. He was the one who took the idea initially from the gentleman which I had quoted in the beginning. And he said that the divide and rule policy which the Britishers had worked with, that has to go. Because if we remember, the only way the Britishers could succeed into conquering India and ruling for so many years was on divide and rule. And divide and rule policy on what? On the basis of caste, creed, religion, sex. This is what was essentially the guiding force behind the British rule. So, Mr. Munshi said that we have to do away with this divide and rule. And he was the one who first suggested that there should be protection for every religion, there should be protection for every caste, there should be protection for every section of the society, economically, backward, whichever. So this is where he sowed the thought of protection of everybody. And last but not the least, there was one Mr. Alladi Krishnaswamy Iyer. He was one of the greatest in this particular drafting committee. And he brought this entire different documentation together. And he put the idea that while we constitute the Supreme Court, let us give them some powers which will be the protector of everybody's rights. That is how today Article 32 of the Constitution is itself a fundamental right and is the supreme protector of that provision, is the supreme protector of everybody's rights. Similarly, we go to the High Court in a writ petition under 226 of the Constitution. We have 5 different types of writs. These writs were all known in English law, but they had to be put in the Indian law. It was this gentleman who said that why not make this as a fundamental part of the Constitution to protect citizenry and to protect citizens' rights. So these were the people who essentially brought together the Indian Constitution. Now, it was mentioned that the Constitution took 3 long years. I'll just read one paragraph on the Indian Constitution. 11 sessions of the Constituent Assembly had consumed 165 days. The 7th, 8th, 9th, 10th and 11th sessions were devoted to the consideration of the draft Constitution. The Assembly spent 114 days for consideration of the draft Constitution. Coming to the drafting committee, it was elected by the Constituent Assembly on 29th August 1947. It held its first meeting on 30th August. It was engaged in the preparation of draft Constitution and set for 141 days. Draft Constitution was prepared by the Constitutional Advisor as a text for drafting committee. It originally consisted of 243 articles and 13 schedules. Draft Constitution presented by the drafting committee contained 315 articles and 8 schedules. At the end of the stage, the number of articles in the draft Constitution increased to 386, and finally it had 395 articles and 8 schedules. Now, we will be surprised with the number of amendments that the Constitution went through before we got the final draft. The total number of amendments on the draft Constitution table was 7,635, and the number of amendments actually moved were 2,473. That much work went in deciding what to put, what not to put, how to word it. And now kindly see the irony. That time, after doing 2,473 amendments to the draft, we got a document called the Constitution of India, which finally had 395 provisions and schedules from 1950, and we thought that was the final document in 1950. This is what now will guide us in the years ahead. From 1950 to 2022 today, that Constitution has seen a further 102 amendments. And there are further more schedules added, there are further more provisions which are added. So if we see what we thought was the supreme document then, it has turned out that it could never finally define the rights. It is a guiding force of our rights. But the number of changes that it has gone through, the number of interpretations it has gone through, but nevertheless, this document remains to be an important document. Today, moment we feel that our right is violated, we knock the court of the High Court or the Supreme Court. Even recently we have seen that what we thought was some settled position of law, that this is how it is, it keeps changing. Well, we also have a political crowd. We thought that we knew the election law well, and now the election law has been subjected to so many interpretations. We thought we could amend the Constitution to find a way out of earlier Supreme Court judgments. So we amended provisions. Those amended provisions have again been interpreted by the Supreme Court. So this goes on and on. We don't know where this will stop. The reason why I'm pointing this out to you is, we thought that this is what the Constitution was, and this is what the Constitution has given us. And rightly so. The makers of the Constitution had a particular vision of India. And the makers thought that this, what we have put in this book, will guide us. And if we see the original Constitution, the original preamble, it had sovereign, democratic, republic. The word socialist, secular came in later, because we realized that this is what India was and India should be. Now the question is, have we attained real secularism? Do we really have that equality before us? Do we have that fraternity which the Constitution thought we would have? Do we have that freedom? Is what we have to ask us. And if we feel that we have to achieve the objective of Ambedkar sir, what vision he had as the guiding document, we can achieve this if the state does the directive principles and we as citizens do those fundamental duties. If you see the fundamental duties that is there in this pamphlet which is circulated today, to abide by the Constitution, to follow the noble ideas that inspired the national struggle for freedom, uphold and protect sovereignty, unity, integrity of India, defend the country, promote harmony, preserve rich heritage, preserve the environment, safeguard public property, etc. Now, while this is mentioned as fundamental duty, if we read it very carefully, everything what is mentioned as a duty in here is correlated to our right. We say that we have a right to put up a hotel along the beach side. Where is our corresponding duty to protect the environment? Same way, we talk that as a religious practice we are entitled to do something. But while doing a religious practice, not to do communal disharmony is something which is our duty. So if we see this document, the Constitution, is, while it is a protector of our right, it is also the document of what should be our duty. And I think today on Constitution Day, more than saying that this is our right, I think the time is to say that this is our duty. So if we do our duty, the right will always be there and it will always be protected. And I just read the article by Leofat sir today. I think this is exactly the question which he has posed also in that article. That what was the vision of the makers of the document? Is India heading in that direction? And we as citizens, have we really achieved the object of that Constitution? I leave you with that thought, whether we have actually lived with the Constitution the way it should. Thank you.